Namaskar and very warm welcome to all of you in Sansad TV. I'm Anurag Puneta with you. Today we are going to discuss Indian judicial system and the pressing issues in front of the judiciary. Indian judiciary faces certain integral issues, and chief among them is the slow delivery of justice. Over the years, the Law Commission of India has recommended several reforms, and there have been reports by Justice J.S. Rankin in 1925, Justice S.R. Das in 1949, and Justice V.S. Malamat in 2003. Civil society organizations have also released reports on the justice delivery system. But despite so many efforts, the problem of justice delivery system in India have remained. Voicing some of these concerns, Chief Justice of India, Mr. N.V. Ramana, has called the Indianization of the country's legal system the need of the hour. He also said it is crucial to make the justice delivery system more accessible and effective. According to the CJI, courts need to be litigant-centric, while simplification of the justice delivery should be the pressing concern. And he says, and I quote, very often our justice delivery poses many barriers for the common people. The working and the style of the court do not sit well with the complexities of India. Our system, practice, rules being colonial in origin, it may not be the best suited to the needs of the Indian population, unquote. The CJI also clarified that by Indianization, he means the localization of the justice delivery system. And for example, he said, parties from a rural place fighting a family dispute are usually made to feel out of place in court. And they do not understand the arguments or pleadings which are mostly in English language, a language alien to them. And these days, judgments have become very lengthy, which further complicates the position of litigants. And for the parties to understand the implication of judgment, they are forced to spend more money. And judiciary infrastructure, if we talk about the steps taken by the government, though government has taken several steps, since 93-94, approximately more than 8,000 crore have been spent on infrastructure. Among them, court halls increased from 15,818 in 2014 to 20,218 in 21. And from 10,211 in 2014, residential units have also increased to more than 17,000 by 2021. If we talk about the court halls, 2,693 court halls and 1,852 residential units are still under construction. If we talk about the infra development scheme for the judiciary, expanded till 25-26 infra schemes to cost 9,000 crore, and Central would share among them the more than 5,000 crore rupees. And if we talk further, lawyers' hall, toilets, computer rooms in the courts, that have also been increased, and government implementing e-courts mission mode project also. Computerized courts have increased from 2014 to 2021, 13,000 to more than 18,000 by 2021. Web portal provides e-court service like case registration, etc. And this makes life easier for a common person. Judicial service center in computerized courts and e-courts have also been increased. Litigants can access case status of over 18,000 crore cases now. Virtual court set up in 12 cities to try traffic offenses. And this is very, very encouraging. And video conferencing in 3,240 courts, complexes, and 1,272 in jails have also been implemented. These are the steps have been taken by the various organizations. Virtual court set up in judiciary service in 12 cities to try traffic offenses, as we told. And these courts handled 75 lakh cases and realized more than 160 crore rupees in fines. And web portal provides e-court services like case registration, list status, and judicial service centers. And computerized courts have also made life easier for a common person. Video conferencing mainstay during the lockdown, especially since last 1 year, and more than 96,000 virtual hearings in Supreme Court took place since last almost 1 year. More than 43,000 cases heard in High Court since last 1 year almost. And more than 74 lakh cases in district courts have been heard during the lockdown period. 35 Supreme Court judges appointed since 2014, and 602 new judges in High Court have also been appointed. So steps are being taken, but the Chief Justice of India raised a very pertinent issue about Indianization of the judicial system, and by means that we are going to raise several issues. 551 additional judges made permanent. High Court judges have also been given the extension and promotion as well. But despite this very pertinent issue, there are pressing issues in front of the judicial system, and we are going to raise that will language of the litigation change in the district court especially, and how can district courts be changed especially, and this would be very, very pressing. How can pendency be tackled? And this is a huge issue. And can case management reduce workload? These are the questions that we are going to raise in this edition of Perspective. We have with us two experts. We are going to discuss these issues with them. Let me introduce them. I have joined by Mr. P.K. Malhotra, who has been the former Secretary of Government of India. Very warm welcome in the show, Mr. Malhotra. My second guest is Mr. Nigam, who has been Advocate of Supreme Court of India. Very warm welcome in the show to both of my guests. Mr. Malhotra, I would be starting with you. How do you see Chief Justice of India's statement that Indianization of the judicial system is a need of the hour?
See, Indianization of the justice system in India is not being discussed for the first time. I think the statement made by the Chief Justice of India is timely when the government itself is taking so many judicial reforms, doing so many judicial reforms. It is an ongoing process. Indianization and judicial reform, when we talk of, I think we have to take into consideration what our reforms have taken place so far. The number of judges has been increased, but not to the desired expectations. We are using technology for the last 20 years. The steps have been taken to use technology into the justice delivery system. And during the last 5 years, the pace has accelerated. Not only that, certain amendments have been made in the procedural laws, including the Evidence Act, the CPC, and the CRPC, whereby the timelines have been prescribed for trial of certain offence or for disposal of certain cases. Similarly, the constitution of various tribunals to deal with specialized issue, to decide the cases based on the principles of natural justice has also been done. But in spite of that, we find that the pendency in the courts is increasing. As in today, it is said that there are more than 4.5 crore cases pending in the judiciary. About 65,000 cases are pending in the Supreme Court alone, and about 60 lakh cases are pending with the various high courts. And one of the judges has made a comment recently that even if no new cases are filed, to clear the existing vacancies and backlog itself, it will take judiciary almost 100 years. If that is the situation, then I think what the Chief Justice of India says becomes very important. It's not that the steps have not been taken. The Department of Justice in the Ministry of Law and Justice always keeps on meeting the judiciary people as well as people from the profession, and in coordination with the government, the steps are being taken. The judges' strength has been increased. In spite of that increase, of course, the number is not up to the desired level as it is in European countries. In European countries, the judges' strength is, say, there is, for 1 million people, there are 70 to 100 judges, whereas in our country, it's only 18 to 20 judges. I think all these reforms which have taken place probably need to be accelerated, and the judicial discipline which is required in the conduct of the proceeding also become more important, where we find that the judges should also lay down the timeline with which the argument should be finished, or the argument should be filed. Written argument should be filed instead of extending the oral argument. Similarly, the adjournments which are given, frequent adjournment, that need to be restricted. Advocates are also supposed to play an important role in the justice delivery system because they are the officers of the court. And they also must ensure that unnecessarily adjournments are not sought so that the cases can be decided as expeditiously as possible without going into the nitty-gritty of procedural aspects, but without compromising with the justice delivery system and the basic principles of natural justice.
Okay. Mr. Nigam, what do you think? I mean, Indianization of the judicial system is a very, very catchy word, if we can say. But will the language of the court change at the district level? I mean, this is a huge task. What do you make of the statement of the CJI?
No, Anuragji, the issue is very pertinent and relevant in today's time because our entire colonial system was based from the point of view of master-servant relationship. And not from the public's point of view or people's point of view. So they created a system which suited them. And therefore, there is a need to, change this system as pointed out by others also, many experts, that you have to empower your Panchayati Raj institutions. And all those small, simple cases should not clog our normal court system. It should be given to them. And you trust them and you will have a very good and excellent system. Second is the use of Indian languages in court at the grassroots level, at the district level, which is very, very important because people don't even understand what is going on inside the court, what is written in the pleadings and in the petitions. So Indianization has to start at the grassroots level. Even in fact, the Supreme Court judgments have also now been translated in Hindi and I think some other languages also. So all this is, taking justice to the people. We have to remove the complexities and make it as simple as possible. And local conditions also have to be taken into account. Like particular kind of cases are arising in particular regions, or crime cases are more in particular regions. All those factors, if are taken into consideration, then we would be, giving due importance to local conditions, which means Indianization of the entire judicial system and legal system. And training is also very important. Training of our judicial officers, of the lawyers, to an important part of the legal system, because without that, they will not be able to, deliver anything. And the alternative dispute resolution, which I will elaborate further in due course, is also very, very important in today's scenario.
Okay. Mr. Malhotra, if I ask you one more thing, time that what CJI has suggested, that Indianization means, people from the rural area don't understand the language of the court. They find it difficult to understand the litigation language and they spend more money on that. So if this reform has to start, it has to start from the bottom, from the district level. Don't you think it is easier said than done as far as the practicality is concerned?
Yes, I think you have raised a very pertinent issue, and my co-panelist has also, made an observation of that. But the fact remains in the lower courts, the use of local languages, it's not that it is not permitted, it is permitted, but most of the judges. And that can be achieved only when the court decides the case in the language which I understand. So use of the local language definitely becomes very, very important, and it is one of the part of the Indianization. But as you very rightly said, it's easier said than done. It will take time, but even if it takes time, you have to make beginning somewhere. And if the judiciary is now inclined, why not to make that beginning today itself? Whatever steps have already been taken, we should accelerate those steps. Like take for example, the use of technology in our day-to-day functioning of the courts. It has definitely brought a sea change during the last 7, 8, 10 years in the judicial system. People now know when their case is likely to come. Moment Supreme Court delivers a judgment, within 5 minutes you get the judgment on your internet, unless you want a certified copy from the court. Immediately you can download it from your computer. So I think this kind of improvements have come. They're all part of the Indianization. But more importantly, as I was saying earlier, I think enforcing the Panchayat Gram Nyayalaya system is more important. We already have a legislation to that effect. But unfortunately, the states are not implementing legal service under the Legal Service Authorities Act. When we are conducting the Lok Adalat, the Lok Adalats are also deciding the cases following the principles of natural justice. These systems are needed to be promoted to dispose of the cases which doesn't involve constitutional issues.
Okay. Mr. Nigam, Mr. Malhotra has raised a very, very important issue. Probably this would be far more practical. It can be started from the Gram Panchayat level to local Adalat, where the Indianization can be started. Well, in terms of the language, though it seems very, very difficult task. India has a diverse country where we have so many languages. So it can somehow pave the way from the bottom.
Anuragji, let us be very clear that everything is being done under the existing judicial system. And existing judicial system is, even the reforms are under the colonial mindset, and colonial structure is there, which was set up by the British. And in order to meet the challenges of the diversity and immense amount of cultural diversity and social diversity in our country, we need to adopt the alternative dispute aspect. In fact, Government of India is ready with a bill which is final. It will be introduced in the Parliament as and when the sessions take place. And therefore, mediation is one place where you can come out of the procedural delays, complex processes of the civil procedure code or criminal procedure code, and you can sit across the table and reach some kind of an amicable solution. This will reduce the delay. This will reduce the pendency of the cases. This will also, be very cost effective for the people where large section of the population cannot afford. And another important point is that if you look at the judgments, most of the things which are quoted are from Western literature, Western jurisprudence. But we have ignored. I, as a lawyer, was never taught what was there in Vedic laws, what was there in Quran and Upanishad, what was there in Kautilya's Arthashastra in detail. So all this has to come, and you have to find out ideas from there also, and have to teach them to the lawyers. Even it has to be introduced at the school level, where you know how trustworthy and honest system we had in the past, and slowly, I will not suggest sudden changes. Slowly, you move from one system to the other, taking our ancient values and traditions into account, as well as the ground level local realities.
Yeah, you are very right. I mean, we have had a very vibrant and probably very democratic and seen judicial system, but we have been made to believe that only the British taught us this entire civilization, or let's say the judicial system. But Mr. Malhotra, I now come to you. It is also said that pendency of the cases is a huge issue. I mean, we often get to know and probably read in the newspaper. But it is also said that probably the Indian judicial system doesn't have a effective case management. So do you think if we have the effective case management to solve this pendency issue?
You see, case management is only one of the way by which a disposal of the cases can be expedited. And it is not that the case management system is not being adopted. Let me share my own experience with the audience here, with the participants and the audience here.
Okay.
You see, when I was working as a judicial member of the Income Tax Appellate Tribunal, way back in 2003, 2004, 2005, at that time, the pendency in the Income Tax Appellate Tribunal, which decided for second appeal again the direct tax matters, the pendency was about 3 lakh of cases. But it is only because the case management system was introduced in the tribunal, and even the members of the tribunal were asked to look into the cases, and if there are cases which have a common issue, they should be clubbed together, heard together, or if an important issue is there, decide by it a larger bench, and that decision should be applied to all the pending cases. By adopting that kind of practice, the pendency was reduced from 3 lakh to 80,000. So this kind of practices are being adopted even by the other courts also. And now, at least we have an advantage of using the technology. I think by using the artificial intelligence also, probably this can be done. Use of technology in a big way can make a difference in reducing the pendency by way of case management. And Supreme Court has already moved in this direction when they introduced a system known as SUPACE, SUPACE, which means that it is being done on trial basis. I think under the chairmanship of Justice Chandrachud, a committee was working, and the present Chief Justice inaugurated the system whereby the criminal appeals in Bombay High Court and Delhi High Court will be solved through by using artificial intelligence. What the artificial intelligence will be doing, all the research work which is to be done, what are the important facts of the case, what is the applicable case law, how it has to be analyzed, that thing will be coming before the judge by way of artificial intelligence. And after that, the judge will be in a position to take a decision quickly as to how the decision should go, whether it should go in favor, whether appeal should be allowed or should not be allowed. This is use of technology. But just to supplement what Mr. Deshratan has said, so far as arbitration and mediation is concerned, we have a dedicated law under the Arbitration and Conciliation Act of 1996. But for mediation, we don't have a dedicated law as in today. So dedicated law is under consideration of the government. But at the same time, it's not that the mediation is not practiced. We are in fact practicing mediation. Section 89 of the CPC already make a provision, and since 1992, when the amendment was made, the dispute can be resolved through arbitration, mediation, conciliation, or negotiation, or through lok adalat. If that is possible, the courts mandate and other court persuade a party to do it. Unfortunately, I think the mindset of the people needs to be changed. I think this is the right time when the mindset of the people, the litigant, as well as the judges, as well as of the advocate must change. And they should adopt an approach of mediation whereby the dispute can be resolved as early as possible. Mahatma Gandhi in his autobiography has also said when he adopted this approach, he didn't lose anything, not even money, not even his conscience. I think that's a very good statement made by Mahatma Gandhi, saying that by mediation, disputes can be resolved much quickly, which is again a part of the Indian system. It's not that the other countries are not following it. Other countries are also following it. But I think we are the person, as Mr. Deshatan also said, from Vedic time, if you look, this is the method which was being adopted.
Okay. Mediation can somehow be the very savior. Mr. Nigam, are you of the same opinion what Mr. Malhotra is saying? Because the pressing issue is there in front of the nation, that how to reduce the pendency in the court.
Yes, in fact, let me point out, people say that the mediation has come from the West, but Bhagwan Shri Krishna was the first mediator that we know that who did mediation between the Kauravas and Pandavas, and when he exhausted all means, then the war took place.
Yeah,
and therefore, mediation is one of the most important aspects of our life, where at every stage elders do mediation, and even at the panchayat level also mediation is done. So it is ingrained in the minds of people. But it is not mandatory. Therefore, it is required, this process has to be made mandatory between the parties, that before you go to the court, you have to go to the process of mediation. That will greatly reduce the pendency and also increase the satisfaction level of the people. Because in mediation, the parties take decision. There is win-win situation. Nobody loses, nobody wins. So there it's a win-win situation. Parties come to a settlement on their own terms with the help of a mediator. So I think this is one of the most favored option over all other options, including arbitration and others, to Indianize it. And there also local customs, traditions, and the thought process of people can also be taken into account in mediation, because it is very wide.
Okay, okay. Now comes the another question to Malhotra, that government is also all the time, I mean, whether irrespective of the party, I mean, every time the government is accused of not letting the reforms take place in the judiciary system. I mean, the sanctioning strength of the judges are not filled. This is also one of the accusations. What is your opinion about it? It is always heard in the newspaper and the media that number of posts of the judges are vacant in Supreme Court, High Court, and the lower courts as well.
I think it will be incorrect to blame any one organ of the government for the vacancies in the judiciary. Collectively, I think judiciary is also equally responsible when the recommendation by the collegium are not made in time for consideration of the government. Because government, when the recommendation come to it, has to follow its own procedure, has to verify the credential of the person, has to take IB report and follow the procedural requirement. And if the process is started well in advance in accordance with the procedure laid down under the standing operating procedure or the memorandum of the memorandum which has been signed between the executive and the judiciary, if that procedure itself is followed in a time-bound manner, I think the appointment process can be expedited. So you can't blame one organ of the government. The failure is on the part of both on the part of the judiciary. Now, take for example, if you are talking about the executive. Now, tell me the appointment in the lower judiciary are made by the judiciary itself. High Court, which makes the appointment of magistrate and the session judge. Why there are 40% of the posts in the lower judiciary also lying vacant if executive is to be blamed? So I think it is a systemic failure which needs to be improved, and there is a need for better coordination between the two organizations, two organs of the government, so that the process is expedited and the action is taken in a time-bound manner to fill up these vacancies. When that doesn't happen, this kind of problem arises. The government did come out with a National Judicial Appointment Commission bill, and the constitution was also amended, but unfortunately, the Supreme Court struck down it, saying that it is unconstitutional and it destroys the basic structure of the constitution. Personally, I mean, speaking for myself, I think there is a need to reconsider that particular aspect, and whatever deficiencies were noticed in that particular amendment which was made by the parliament, by removing those or by looking into those aspects, if this kind of bill is again brought so that there is a statutory provision as to how the appointment in the judiciary will be governed, I think that will be a better option for us for filling up these vacancies in a time-bound manner, expeditiously, and in a more transparent way than it is happening as on today.
Okay. Mr. Nigam, the same thing to you. I mean, the same question to you. The government tried to implement its own law, I mean, passed by both the House of the Parliament, but Supreme Court refused it. I mean, Supreme Court threw it, that law. now the collegial system is also not working in tandem with the entire system. So probably you cannot blame, as suggested by Mr. Malhotra, that you cannot entirely blame the one organ of the system. So how do you see this issue that number of the posts of the judges are still vacant in the various courts?
Anuragji, the original position of the Constitution was the appointments were to be made by the executive in consultation with the judiciary, so far as high courts and Supreme Courts are concerned. That was the basic structure of the Constitution. But Supreme Court, through its various first judge's case and second judge's case and third judge's case, took away that power from the executive and started appointing judges by themselves. So you cannot be a judge in your own cause. You cannot appoint yourself. Because in a democracy where will of the people is supreme, we need a system where whoever appoints a judge should be accountable to the people directly, so that if you make a bad appointment or a wrong appointment, the people will ask you questions in the next elections. So this collegial system is non-transparent, opaque, and lot of issues of nepotism are also there. I know a case of a judge who bypassed 41 judges and was appointed. So these are the very serious issues and requires a complete thorough relook and review of the collegial system, and the appointment system must go back to the people who are answerable to the people of this country.
Okay. So on this note, we have to wrap up the show. Thank you to both of my guests for joining. So Chief Justice of India clarified many things, that Indianization is the need of the hour, and what he means of Indianization, that localization of the judicial justice delivery system. And he gave the example that said that the parties from a rural place fighting a family dispute are usually made to feel out of place in the court. They do not understand the arguments or pleadings, which are mostly in English language. This language is alien to them. And these days, judgments have become very lengthy, which further complicates the position of litigants. And for the parties to understand the implications of a judgment, they are forced to spend more money. So this is the concern raised by Chief Justice of India. And if the steps are taken in that direction, and this will be a sea change reform in the Indian judicial system. That's all we have in this edition of Perspective. Thank you very much for watching Sansad TV.